Next up is Simran Singh versus Carrie Harris. This is filed as a termination of tenancy matter. Notice to quit. Was February 16th. This is apartment 1. Mr. Singh, am I correct? You're simply asking that she move out?
Yes, Your Honor.
Ms. Harris, what's your position?
My position is there is no place for me to go. And I was paying my rent up until our last court date that we had, and they refused to meet with me and go over things. So I'm kind of stuck. That's my position. I don't know. I've put applications in. I've tried to get help from the state. There's nowhere for me to go. And I'm willing to pay my rent, but they refuse to meet with me to go over paperwork of things that I have that they don't have.
Once they file a termination of tenancy, they can't accept rent. So he doesn't want you to pay, he just wants you to move. I didn't look up the previous case. I think we got sort of halfway. Who else is there? It's Carrie Harris and all other occupants.
Chuck.
Who else is there?
There's one more guy, Your Honor. I don't know his name. Chuck?
Chuck Statics.
He lives there also?
Yes.
Is he on the lease?
No.
All
But they knew he was living there.
Ma'am, are you a whore?
That I adjourn this matter at least 7 days. I'm going to continue this to April 6th. I can't adjourn it to next Friday because that's a court holiday. And we'll make it at 2:20. Ms. Harris, if Mr. Singh gets what he asked for, you and Chuck are going to have to move out 10 days after April 6th. He's not asking you to pay money. He's asking you to vacate. You've got an unlawful tenant
stuck like Chuck
in there, which is an additional reason why he wants you to move.
Unlawful. He
has filed for money damages, I think. Nope, no money damages.
That was the last time.
So this is simply a possession issue, not a money or rent issue. Once you move out, if he does seek money damages, we can have a hearing where people are sworn under oath and I take testimony about who owes who how much money. Calculate if there's a security deposit, how much rent is there, that sort of thing. At this point, he simply wants you to move. This process is for people who can't move because otherwise they would never move. There aren't enough places to move to. There's not enough housing, period. And there's certainly not enough affordable housing. But the landlord doesn't have to be compelled to have you stay there. So the sheriff comes and puts your stuff out in the street. That's not a very good solution. So I'm adjourning this matter 10 days till April 6th. You get an additional 10 days from that day to vacate or be subject to being evicted. So the target date for you to look at to be out by would be by April 16th if he gets what he asks for. Do you understand?
Yes, Your Honor.
Do you have any questions?
No, I guess not. I mean, I've got paperwork and everything. I don't even know why this is going on because I paid my rent. But
Now you're going to cry. Where?
Well,
I've been there for 4 years.
he's not asking you to pay the rent. He's asking you to move.
That's the whole reason why he took me to court. Supposedly, if I have a $500 water bill that I never got a copy of, how is this all fair? I don't get it. I've been there for 4 years.
Mr. Singh, when was rent last paid?
Your Honor, she paid me.
Happy birthday, Andrea.
Right here. She paid me $550 in January. She paid me $250 in December. And she haven't paid me her balance of $450 in January, nothing paid in February, nothing paid in March. And she
Well, that's
just,
because you, stop. That's
right.
because you filed a termination of tenancy.
absolutely, right.
So it is
absolutely.
though she
Yeah,
wasn't willing to pay it.
Yeah, and then
Once
she
you
had,
file a termination of tenancy, you can't accept rent. So
right.
I was just wondering if she was like thousands of dollars behind in the rent.
No. It's
She's
not like
apparently
that.
not.
Your Honor, it's just that she doesn't communicate. I mean, and then I just want my property back. It's just so
All
many
right.
years. So yeah, I just request to get it back.
Your Honor, I have
Yes.
text messages that I have them telling me no more talking. I just want my house back. They don't send me the. How am I not talking to them? They refuse to meet with me,
All
and
right,
that's why.
Stop. I don't, is there a lease in effect? There was no lease filed with this.
There is a lease.
From when to when?
I'm on month to month. I've been there.
Yes, that's what I thought.
Yeah. And I haven't paid rent since the last court date because they refused to meet with me and go over.
That's correct. You're not supposed to. All right, it doesn't have to be fair. He's the landlord. You have a month-to-month tenancy. He gave you more than a month's notice to vacate. You didn't vacate, so he filed the case. So he's asking for his property back. Let's say he wants to move his brother-in-law in there, or he wants to empty it so he can refurbish it, or he wants to empty it so he can sell the building, or he wants to empty it so he can tear it down. This is the process you go through to do that. When you have a month-to-month lease, you don't have indefinite right to the premises. You have a month's notice, and then it starts this process. So he served a notice to quit on you, and
I know, and I have nowhere to go, Your Honor. I mean, where am I?
all right, and that's not uncommon. There is no, I have nowhere to go in exception to the fact that I have to make a landlord keep somebody as a tenant they don't wish to have. So you can consult with legal aid. They're here.
I have.
You
I've
can
already got a hold of DHS.
hire a lawyer, or you can prepare to vacate. But we're going to continue this matter to April 6th at 2:20.
All right.
All right, you're good to go.
Thank you, Your Honor.
Next up is
Joseph Getz versus Joshua West.
Morning, Your Honor.
Okay. Mr. West, I'd appreciate you not smoking.
Yeah, no, I'm not.
Okay. All right. Mr. Getz,
Yes, Your
what
Honor.
is what is your claim in this case?
So he hasn't been paying rent for the last 2 months. We're approaching a third month without him paying rent. I tried to serve a notice to vacate on the first month and I didn't use the right paperwork. So I served a 7-day notice to quit.
Okay. So, sir, how much does he owe?
At this current moment, $1,400.
All right. Then you've got costs, it looks like here, about 87. All right. Sir, Mr. West,
Yeah.
how are you intending on getting this paid?
Well, what happened was when I moved here, I didn't have any money. And I've known this guy since like first grade. He told me it was cool. And I got 2 jobs and I started paying the rent. And the rent there was never any lease signed or anything. I never got, but the deal was that when I started working, I didn't have, it was like, I'll give you the money when I get paid. And in January, I paid him on the 23rd. And then in February, he got all drunk and started freaking out and told me he was going to throw all my stuff out and started putting my stuff in boxes and throwing my food away. That's why I didn't pay the rent. And I would have moved out if I had anywhere else to go. But
All right.
I don't have anywhere else to go. So
Do you this is a non-payment case, so do you have the money to pay?
no, not now I don't.
Okay.
Yeah. I moved in here and this guy told me he was on felony probation and he wasn't drinking, and then he's drunk every day going crazy, and I ended up getting fired because I didn't sleep for a week dealing with this. Like
Okay.
it wasn't like I just didn't pay the rent. Like I'm trying to get it together
All right,
and get
here's
out of
what we
here.
do. Second service wasn't paid for. What I'm gonna
I
suggest.
don't know
that you
I don't know what
accumulate-
that means. I don't know what
Well,
that means.
There's not a second service by the court, which means I can't take a default or do anything today. I'm gonna adjourn this out. Mr. West, if you think that you need an attorney, and for that matter, Mr. Guest, if you think you need an attorney, that'd be your opportunity to hire an attorney. We'll adjourn this out to April 10th, 2026 at 2 p.m. That's an
2 p.m.
in-person hearing, and I'll need you both down here at the courthouse. All right?
You said April 10th?
Mr. West, April 10th, 2 p.m. Mr. West,
Okay.
in the interim, what I'd suggest you do is accumulate what funds you can when you come down, because I think Mr. Getz is probably correct. Another month is going to click in by the time you get back here. And so there's going to need to at least be a payment while you guys try to work this out. All right?
I would pay it if I had the money. I don't have the money. It's not that I wouldn't pay it. I've been trying to find a job.
I hear you. What I'm indicating, though, is that you said you had jobs
Not
so-
anymore. Not anymore. All my
because you got fired.
yeah.
Okay, well, okay. So we'll see you guys down here April 10th,
Okay, Josh, you can just stay there the rest of your life and not pay.
2 p.m.
Thank you,
In
Your
Berlin.
Honor.
Okay.
All right.
Do
Thank
I
you.
have to do anything else right now, or?
Well, if you want to hire an attorney, you can, or if you want to seek assistance, you can call the numbers that were on the slideshow at the very beginning. You can
Okay.
call Hawk. Did you get that number?
No.
All right, you got something? Do you have something to write with?
Hold on one second. I do. Okay.
They are 961-1999. That's area code 734.
734-961-1999.
Yes, sir.
And what was it called again?
It's called HAWC. That's an acronym. It's HAWC. Housing Access for Washtenaw County.
Okay, and you said April 10th at 2 p.m.?
Yes, sir. In person.
Is that just Saline Courthouse, or like to get
No,
directions?
you're gonna come to the courthouse I'm at, which is the one by the sheriff's department.
What sheriff's department? In
What?
Saline? Or?
No. All right.
I just moved here in October. I'm not from. I don't know.
Okay,
where-
no, I got you. I'm just
I'm
trying to
not
explain
trying
it
to-
to you.
yeah. I'm not trying to
No,
give you a hard
just try-
time.
Sir, I'm just trying to tell you how to get here.
Okay.
The address is 4133 Washtenaw Avenue.
Okay.
Okay, and it's right off of US 23.
Okay.
All right. So if you were to just ask or put in your phone the Washtenaw County Sheriff's Department, it'll show you this location. We're right attached with them.
Okay. Well, if I don't get some money, my phone's gonna get turned off. Can I still show up and do this without my phone?
Oh yeah, you can show
Okay,
up.
okay.
I was saying use your phone to find the location.
Yeah. Okay. Yeah.
All right. We'll see everybody April 10th.
Thank you, Your
What?
Honor.
Okay. Thank you.
All right. Thank you.
Do I just
That's
hang
it.
up now?
Yep. Hang up.
Okay.
You're
Thank
good.
you.
All right. Okay. Court's in recess.
Oh my God.
All rise.
Thank you, everyone. Let's take a seat, please. There are two files, 251379FH and 251380FH. Both are captioned People of the State of Michigan versus Kenneth Street. I see Mr. Street is here along with his attorney, Mr. Doug Corwin, our public defender. Mr. Kerner is present, our elected prosecutor, sitting at council table from the Michigan Department of Corrections, Agents Hobson and Rolfe. Mr. Street was before the court last. That would have been March 19th. And on that date, the court had advised him that his probation agent had made allegations that he had violated probation. The allegations were that Mr. Street was and continued to contact the victim of his crime, which according to his orders of probation, he specifically prohibited from having any contact with the victim of his crime. Well, the court, after explaining the allegations to Mr. Street, and he said he understood the allegations, and the court had further advised Mr. Street that if he was found guilty of violating probation, sanctions could include additional incarceration. Because that was true, he had a right to plead not guilty, he had a right to be represented by an attorney, and he had a right to a contested hearing. Mr. Street said he understood all of those rights, asked the court to enter a plea of not guilty on his behalf, appoint him counsel, and then set the matter on for a contested hearing. And Mr. Corwin, as you can see, we're in an environment suitable for a contested hearing. How would you like to proceed today?
Talking with Mr. Street, Your Honor, he would plead guilty to the violation.
Thank you, Mr. Corwin. Any objection, Mr. Kerner?
No, Your Honor.
Very well then, Mr. Street, would you raise your right hand with me? Do you promise that you will tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, Your Honor.
Thank you. You may put your hand down. Mr. Street, is it true it's your intention to plead guilty today to the allegations that you violated probation?
Yes, Your Honor.
Would you be pleading guilty because you are, in fact, guilty of violating probation?
Yes, Your Honor.
As your attorney, Mr. Corwin left the final decision as to whether or not to plead guilty up to you.
Yes, Your Honor.
Has he explained to you that you have a right to a hearing and all that entails?
Yes, Your Honor.
Have you concluded, Mr. Street, that it's in your best personal interest to plead guilty and waive your right to have a hearing?
Yes, Your Honor.
Has anybody promised you anything to get you to plead guilty?
No, sir.
Has anybody threatened you or any members of your family to get you to plead guilty?
No, sir.
Do you have any questions of the court?
No, sir.
Very well then, Mr. Street. How do you plead to the allegations that you violated probation?
Guilty.
What did you do that makes you guilty of violating probation?
I contacted my wife.
So your wife is a victim of your crime?
Yes.
Your orders of probation specifically indicate and dictate that you were not to have contact with this individual. Is that correct?
Yes, Your Honor.
And you did it anyway?
Yes, Your Honor.
And by contacting her, you made phone calls from the county jail to her?
Yes, Your Honor.
And you knew that that was a violation of the court order?
Yes, Your Honor.
Is it true you contacted her many times?
Yes, Your Honor.
I find you guilty. There is a probation violation report Mr. Corwin prepared for today's proceedings. Did you get a chance to review that?
To be completely candid with the court, I have not. I got asked to do this hearing. I don't.
Sir, you're not his counsel, are you?
Ms. Houston is.
Okay.
So if I could have just a minute.
You absolutely can. I'm sorry. I assumed that you had a chance to look that over. Well, why don't we just take a recess? Do you want to take a recess, Mr. Corwin?
Yes, 5 minutes.
Yeah, absolutely. All the time you need. Well, Mr. Street, Miss Houston is on vacation, which I never heard of Miss Houston taking a vacation before, so good for her. Do you object to have Mr. Corwin assist you through today's proceedings?
No, sir, Your Honor.
All right, very good. Let's take a break and allow Mr. Corwin to review the probation violation report and make sure that you go over that with Mr. Street too. Would you please?
I will.
Very good. Thank you, everyone. Please, let's take our seats. We'll go back on the record on the two files involving Mr. Kenneth Street. Before we took a break, Mr. Corwin wanted a moment to review the probation violation report. No foul on Mr. Corwin because he's standing in for Ms. Houston. Mr. Corwin, did you get a chance to review the probation violation report?
I did, Your Honor.
Do you agree that there's 147 days credit on each file?
Yes, Your Honor.
And do you have any changes you'd like to see made to the body of that report?
None to the body.
Thank you, Mr. Kerner. Have you had a chance to review the probation violation report? Any changes you'd like to see made to the body of that report? Thank you. Mr. Street, have you had a chance to review the probation violation report?
Yes, Your Honor.
Did your attorney, Mr. Corwin, make himself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
Yes, Your Honor.
As you read through it, Mr. Street, did you find everything in it truthful and accurate?
Yes, Your Honor.
Thank you, Mr. Street. Mr. Corwin, allocution.
Thank you, Your Honor.
You're welcome.
I impressed upon him, and I believe he understands, absolutely cannot call to his former household. It appears he may have been trying to use a different number. As indicated in the report, he understands he cannot contact the children, cannot contact anyone at the house, needs to adhere to it. I'd ask the court to adopt a recommendation, and I'd ask the court for an additional 15 days in jail on this matter. I don't know if the court can tack that on to the...
I already sentenced him to a year, Mr. Corwin. I can't give him any more jail time.
And I asked the court to hold any jail time in abeyance. I talked to him about, he's like, is there any way we can get this lifted? And I said, no, not until you've had treatment. And I would ask grace from the court to not sentence him to Department of Corrections at this time. I've very well advised him. I believe he understands. I don't anticipate he'll call again. If he does, the court has no choice but to send him to Department of Corrections.
Thank you, Mr. Corwin. I wish that you had the backstory on this case, just so you understood. We'll get into it in a moment, but I appreciate your efforts, Mr. Corwin. Thank you. Mr. Kerner.
I don't think there's any other alternative for this gentleman but incarceration, Your Honor. He just won't comply. I mean, 68 times. I mean, that's what we know about because he was in jail. Who knows how many other times he's violated this no contact order. We've seen in the past, and I appreciate the court did bend over backwards for him. It's not something that we typically would do because
Come on, give him a 69th chance. What's the worst that could happen?
family wins. We know that. But in this case, it loses because he can't stop himself from contacting her. And I believe that the only alternative is incarceration.
Thank you, Mr. Corwin. Mr. Street, this is your opportunity to address the court. What would you like to say?
I messed up. I contacted my family trying to talk to my kids. I know it was a mistake and I won't do it again.
Is there anything else you'd like to say?
No, that's it, Your Honor.
I had an incredible sense of deja vu because we had the same conversation like 5 times.
Yes.
And you tell me the same thing. I promise I won't do it again. And then you do it again. So we look back, Mr. Street, this is incredibly frustrating to the court because like Mr. Kerner said, we've been over backwards to try to help you. You were sentenced on February 20th of the year 2026. It was domestic violence, 3rd offense. Your wife was your victim. And I remember telling you, Mr. Street, today's Friday. We're gonna let you out on Monday, but you have to promise me you're not gonna call your victim. You're not gonna call your wife. And if we went back and looked at the transcript, it would say something like this: Mr. Street, I promise you that in the future you'll be able to contact your wife again, but not until you're treated, right? And when whatever's wrong is fixed. And you said, I understand. I said, but you have to get help first. You said you understood. And I said, is there going to be a problem, Mr. Street? And you said, there's not going to be a problem, Judge Stewart. I'm not going to contact my wife. No problem. We'll wait until the time is right. And your wife was here. I said, you need treatment too. She goes, I agree. And then Monday morning, I get a call from the jail, or the probation department got a call from the jail. You're nonstop talking to your wife on the phone from the jail. Unbelievable. So instead of getting out of jail on Monday morning, which would have been February 24th, I held you and asked the probation department to look into these facts to determine if there would be a probation violation, which there was. And you were charged with a probation violation on February 27th of the year 2026. And you continued to call her from the 24th to the 27th. So I said, well, the court's order was, Mr. Street, if you're not going to follow the orders of probation and you're not going to refrain from calling your victim of domestic violence, then I'm not letting you out of jail. And I sentence you to 1 year in the county jail. Am I accurate so far? Does that all check out?
Yes, Your Honor.
And if that wasn't bad enough, since you're sentenced to 1 year in the county jail on February 27th up through March 12th of the year 2026, you contacted her at least 68 times. Is that right?
Yes, Your Honor.
At least 68 times. So then your probation agent said, well, there's new allegations, and he charged you with violating probation yet again for all of these calls. And we met on March 19th of the year 2026. Mr. Street, I can't believe that this is happening again. How do you plead? Not guilty. And then between March 19th and today, you called her again a number of times. Isn't that correct?
Yes, Your Honor.
So you could have got out of jail, but you made the contact. You got a year. You could have just got a year, but then you made the contact. Mr. Street, I have absolutely no choice but to send you to the Michigan Department of Corrections because you won't follow the court's orders. You absolutely will not follow the court's orders. I begged you not to make contact with your victim because you were convicted of assaulting this victim 3 times now. 3 times. I believe that there's a power control mechanism here that you are manipulating the court and you are manipulating the victim. And the only way that I can prevent you from doing that is to remove you from the equation. You have left me absolutely no choice. No choice at all, because there's nothing more that I can do to get you to follow the orders than what I've already done. So the sentence of this court is that you are discharged from probation because you will not or cannot follow its orders. To the extent that you owe fines and costs on each file, they will be preserved and we can use our civil remedies to collect. But you will go to the Michigan Department of Corrections and serve a sentence of at least 23 months on each file, not to exceed 60 months on each file. Against each file, you receive credit of 147 days. These files will run concurrently. And that is your sentence, Mr. Street, and that is your sentence because that's what you deserve. You would not follow orders. You continue to contact your victim and place her in danger in a number of times, and I just can't get you to stop. You have some appellate rights. Mr. Schmidt will approach those rights. What I'd like you to do is initial the form acknowledging that you received it. If you'd like court-appointed counsel, to assist you with an appeal, you've got 42 days from today's date to make that request. Please make sure, Agent Hobson, that the Michigan Department of Corrections is well aware of the problem that this court has in getting Mr. Street to leave his victim alone. Thank you.
It's not a indicted case. It's the one you.
Enjoy prison, dummy.
Oh, this is when you set the bond on. The bond thing.
Oh.
There's.
I know about this one.
Yeah.
Yes, okay.
You just wanted to go over it with today.
All right. There's a matter that was presented to the court yesterday by the Criminal District Attorney's Office for Jefferson County, Texas. And you are Charles Wilson III?
Yes, sir.
And you were here with Mr. Adams, your attorney, and the state's attorney. The state of Texas filed a notice for a review of a bail decision. You had been placed on $65,000 bond for an aggravated assault and a $15,000 bond for family violence. And the state of Texas, the district attorney's office deems that amount is insufficient under the law to ensure that you will properly appear and answer before the court and to ensure the safety of the community and the safety of the victim. And for those reasons, they ask for a review of this bond decision. And the court has 24 hours to make a decision. And so the court made a decision yesterday because of some emergency matters that prevented all of us from getting together, but I had to make a decision. And this court did make a decision finding this finding this request in good cause, for good cause. And upon reviewing the public safety report, the probable cause affidavit, and the other documentation in this file on these cases, the court raised your bonds to $100,000 in each cases, and also ordered that if you post these bonds, you must remain at home. You would be on home confinement, except for allowing to leave home only for necessities of food, medical care, and meeting with your attorney. And you must travel to and from your house in the most direct route possible. You must have a GPS device if you post these bonds so that we know where you are at all time, and to ensure that you're not violating these conditions. And also, I think those are the essential features of what the court did. Now, because the rule of law states I have to make a decision, and we couldn't get together, I asked you and your attorney in the state to have a hearing today to show cause why and present any evidence why the court's decision should not be continued and enforced based upon what the court deemed yesterday. And I'm giving the defense an opportunity to be heard and to present any additional evidence you want me to consider. And so I will consider modifying the bond decision if I find good cause from evidence presented. Go ahead.
Yes, Your Honor. Specifically, Judge, under 17.028, it's the state burden to show that the safety of the community and ensures that the safety of the victim of alleged offense warrants this increase or request to review his bond. Your Honor, we ask that the state disclose you what we would believe to be Brady information as it relates to the state's burden as to safety of the community or the safety of the victims. It's my understanding, and I'll ask that the state to disclose if this is true, that the alleged complainant did not want the bond to be increased, one, and that two, in fact, this Tuesday, she went to the district attorney's office to have the charges dropped. If that is true, and that would be Brady, that would clearly be Brady for purposes of a bond hearing. If she, in fact, went to the DA's office to have the charges dropped, and if, in fact, she did not seek to have this bond increased, then on the legal issue of 17.028, safety of the victim, that's clearly Brady, and that would go to that particular, that's my position. My position would be that would be Brady, and I would ask the state to disclose.
Yeah, we heard you think it's Brady. I don't do this, but that doesn't make any sense to me at all. Because you can prosecute without that person. So Brady's saying you can't withhold exculpatory evidence. That's not exculpatory evidence. That's a strategic advantage at trial, that you don't have the victim on board with you. But it's not exculpatory evidence. Exculpatory evidence is I was in another country when the act occurred. Something like that.
Well, in fact,
and how does your client know that she went and did that? I didn't tell anybody because I don't know about that. How did he know? Has he been in contact with the victim, which he's not supposed to be doing?
Well, let's say this. If in fact that is
yeah.
Again,
if y'all want to conduct a hearing on your own, that's fine. But
I think that's Brady. That's sorry.
The court's decision. The court's decision. Even though the state of Texas always has the burden of proof in these matters because of the presumption of innocence standard, this court still has its own independent access to the probable cause affidavit and the criminal history, which I am required by law to review in determining bond issues. That's why I made my decision and found that the bond was too low and not appropriate under the circumstances this court reviewed. I'm giving the defense an opportunity to present any evidence you want,
and I have evidence
to that the court will consider in whether it will modify my bond order from yesterday. Go ahead.
What Judge Mr. Laird says that he's unaware of that, but if in fact that is true, Our position is that that's Brady, and that would go to the safety of the community and the safety of the victim. And I got some more evidence.
Yeah, Brady.
That's Brady.
Wait, I've got a question. Is it your position that this is Brady? I really want to know.
Our position.
The experience has been this office has been very sensitive about Brady. We all should be. We all are, and I've not found them to intentionally.
No, I'm not saying he's not
Brady material. They honor their oath and conduct it responsibly, just as you do in your.
Yes, sir.
Go ahead.
Judge, I would just ask that I understand he can't do it now, but at some particular point in time, since he does not know, that he look into whether or not the lady came up with the drop charges, and he look into whether or not she did not pursue this. But I got evidence other than that. But that's why I got other evidence.
Okay, that's the court will note that, and it's in the record. But at the end of the day, the decision is in the executive branch of government, not her.
Right.
Somehow, some way, she was a complainant somewhere along the line. And when that happens, then the executive branch of government takes over and does what it does under their responsibilities of the oath that they have taken under the Constitution and the laws of the state of Texas and the United States. So I don't find that they've done anything inappropriate in this case, except follow their oath. And we've had situations where complainants change their mind for whatever reason. The worst thing that can happen, though, is if they decide to change their statements of victimization based upon influence or coercion or even contact on behalf of the defendant, it would be catastrophic for you. Because this court takes no prisoners when that is found to be done. You cannot disrupt what this Constitution stands for and what the laws stand for. And that's what happens sometimes when people behind the scenes try to influence others who are involved in the criminal process improperly. That if that is done, it will be dealt with severely. But nonetheless, I don't have any reason. I don't have any information before me to change what the court's decision was yet. And that's why I'm giving y'all a chance.
And I'm gonna call my client as a witness.
Charles Wilson III.
Yes.
Raise your right hand. You solemnly swear or affirm any statement you make during this hearing shall be the truth, the whole truth, and nothing but the truth. So help you God.
All right.
Yeah, speak out.
Yes, sir.
Okay.
All right.
Your hand. Thank you.
All right, Mr. Wilson, you understand that I'm not going to ask you any questions at all about the facts for this particular offense. I'm not asking you nothing about if you understand that. Yes, sir. And you understand on our rules of evidence that you testifying on a preliminary matter does not subject to the cross-examination for any other issues. The only question that I'm asking you on about is for financial abilities, right?
Before you get through, I don't think that's accurate. I think I can cross-examine him on any issue because part of the rules or part of the reason the judge made his decision was on the safety of the community. So I can talk to him about the offense. So before you put him up there, you better get a ruling.
I don't think that he's subject to cross-examination. All I'm asking him questions is about his basic income and his ability to afford a $65,000 bond.
So he can say ask when he feels like it. He just likes to sound stupid.
Asking about his income has nothing to do with whether or not he committed family violence against this lady. And
I think it does. The issues on bond are the ability to follow the bond conditions and whether his release would be a safety to the community or the victim or others. They can go into this because part of the bond conditions is not to include not to commit first thing, don't commit another offense. But it opens you could possibly open the door for this subject matter to be allowed. Yeah, I got to take a break.
No,
right now. Stand by. I'll be right back. Thank you. And this is
This is the state of Texas has requested a review of.
yes. All right.
All right. Did you hear what I'm not gonna ask you anything about the facts of the case. Don't tell me nothing about the facts of the case, right? You got me? The only thing I'm asking you is a money question. That's it. Got to do with money. Don't say nothing about the case. You got me?
Yes, sir.
All right. So you understand that Judge DeRuin, who initially set this bond, I think he said a $65,000 bond and $15,000 bond, right?
Yes, sir.
All right, so if you go to a bail bondsman and they charge you 10%, that'd be $6,500 and then $1,500. It would be a total of $8,000, right?
Yes, sir.
Okay, right now, do you have $8,000 in any bank account anywhere?
No, sir.
Do you have $8,000 that you could borrow from anybody anywhere?
No, sir.
Do you have $8,000 worth of property that you could sell and make this bond? $8,000. Do you have that anywhere?
No, sir.
At the time that you went to jail, did you have a minimum wage job working at Church's Fried Chicken?
Yes, sir.
So basically, working at Church's Fried Chicken, minimum job, you would probably qualify for some kind of a federal financial aid or something, right?
Sure.
And then as far as a house, apartment, home, you don't own that, you live with your mama, right?
Yes, sir.
So as far as the bond being sufficient for you being able to appear in court, actually, the judge could lower that bond from $65,000 to a lower number because specifically under the rules, when the state of Texas asks for a bond review, and the court pointed out in the prior hearing, the court could actually determine that the existing bond is excessive. So based upon what I read in the court reporter's notes, Judge Stevens can say that that $65,000 bond is excessive because of your financial situation. Is that right?
Sir.
So at the end of the day, I told you I wasn't going to ask you anything about the case, right?
Sure.
And I didn't ask you one thing about the case, right?
Sure.
But in terms of MONEY, a $65,000 bond would be excessive for a man.
Ask an effing question. This is all just a freaking argument that he's asking his client to agree with that his client doesn't understand.
Man who doesn't have a job, he lives with his mama, he has no property that could be sold. And I think, and I let Axford to take judicial notice. I think his age is 23 years old. So a 23-year-old man, no job, when I say no job, you can't work at Church's Chicken if you're in jail right now, right?
My client is a knucklehead. Stupid, no job, no chance. Let him out.
Yes, sir. So you done lost the Church's Chicken job, which is a minimum wage job, right?
Yes, sir.
And at Church's Chicken, you basically frying chicken and doing stuff like that. Is that right?
Yes, sir.
So are you asking the court to do what it can do, which is lower the $65,000 bond to, let's say, $10,000? He can lower it. You understand that? Right? All right, that's all I asked, and I told you I wasn't asking nothing about the case.
Anything to say?
Not on the financial judge.
I find that anything else? I find the bond, the setting that the court made based upon his criminal history and the probable cause affidavit, the circumstances to be fair and appropriate under these circumstances. And I deny the request. And we will set this for.
I don't think it's been indicted though.
Yeah, I guess there's an.
It's been received. It's coming up.
Okay, when the indictment comes, we'll try to get a setting as soon as possible, and then you can resubmit your request.
All right, thank you, Judge.
Thank you. All right, let's go to Calvin Walker. Thank you.
Send it.
Court calls PLV Baker 25-1153.
Mr. Baker is finding his way up to the podium, and so is his attorney, Mr. Doug Corwin. He's our public defender. Miss Messer is here from the Attorney General's office. Agent Rolfe present from the Michigan Department of Corrections. Mr. Baker pled guilty back on January 20th of the year 2026 to 2 counts of failing to pay child support. As a result of those plea-based convictions, the Michigan Department of Corrections did prepare a pre-sentence investigation report a sentencing information report and distributed the same to the parties and to the court. So then we got together on February 27th of the year 2026 for our first sentencing date. With an $11,000 child support arrearage, Mr. Baker got it down to like $5,100. The court considered adjourning the proceedings to see if he could pay the rest of the balance off. But then it drug tested him, and that's when things went south. Mr. Baker was positive for drugs. The court remanded Mr. Baker, and then it tried to help him out. And the court said, look, maybe he won't be positive for long. I'll send somebody over once a week to test Mr. Baker. I didn't appreciate your family calling all the time, wanting to know when you were going to be tested. It was inconvenient and discourteous, but I did. I sent someone over there the week after your sentence date. You're positive. The next week, positive. The next week, positive. And I just said, forget it. We're not going to do it anymore. And we're just going to renotice their sentence date and get here today. And I give up. I'm not going to test you anymore. I don't know what kind of drug regimen you were on, but it just was in your system forever. So I thought, let's just get started. There's no sense waiting anymore. Mr. Baker, would you raise your right hand? Do you promise that you will tell the truth, the whole truth, nothing but the truth? So help you God.
Yes, sir.
All right. Thank you, Mr. Baker. Before I check in with Mr. Baker, we did talk about the SIR back on February 27th. And I think we only had one change, counsel, and that was to PRV 7. That was 10 points total of 62. The GMR did not change. Do you agree, Ms. Messer?
Do, Your Honor. Thank you.
Mr. Corwin.
I do, Your Honor.
Okay. Mr. Baker, did you get a chance to review the pre-sentence investigation report?
Sure.
All right. And did your attorney, Mr. Corwin, did he make himself available to you to answer any questions you might have or address any concerns you may have about the contents of that report?
Sure.
I know that there's going to be a change to the child support arrearage because I know that you made a payment since you've been in jail, and thank you for that. But is everything else in the report truthful and accurate? Thank you. There are several proposed orders of probation. Mr. Baker, did you read those carefully?
Yes, sir.
If you're placed on probation, do you think that you can follow those?
Yes, sir.
Most importantly, do you believe that you can continue to pay your child support? And do you believe that you can get that down to a zero balance during the course of your probation?
Yes, sir.
Thank you. Mr. Corn, do you get a chance to review the PSIR?
I have, Your Honor.
You have any changes you'd like to see made to the body of that report?
As the court noted, the arrearage, I'm not sure if I heard the correct number. It's about $3,667.40 is what I wrote. But I know that outstanding balance was reported.
Ms. Messer, what's our number now?
$3,667.40, Your Honor.
And so Mr. Baker is able to knock off $8,129.28.
Absolutely, Your Honor.
Mr. Corwin.
That is correct, Your Honor.
Any other changes, Mr. Corwin?
We would need to, I believe, change the sentencing date to reflect today's date, and credit would be increased an additional 28 days.
Which would be a total of
69 days, Your Honor.
69 days? Agent Rolfe?
Yes, Your Honor.
Ms. Messer?
Yes, Your Honor, I agree.
Okay. This wasn't your case, Mr. Corwin.
That is correct. This is Miss Husted. She was on vacation at this time. I did meet in the jail to re-go through the report with him, and he consented to me representing him for this matter.
Mr. Baker, do you object to having Mr. Corwin stand in for Miss Husted today?
Sure.
All right, good. Ms. Messer, you had a chance to review the PSIR.
I did, Your Honor.
Any changes you'd like to see made to the body of that document?
Your Honor, just to note, I do see that this says 4-year max for each one of these offenses, but I do believe Mr. Baker pled as a habitual third offender.
He did.
8-year max. Which
Ms. Messer is correct, Agent Rolfe. It should be 8 years. Stat max on both counts. Thank you. Good point.
Yes, Your Honor.
Anything else then, Ms. Messer?
No, Your Honor. Thank you.
Thank you. We've already talked about the guidelines. There was a letter that the court received from your daughter.
Yes, sir.
Did you get a chance to read that?
Yes, sir.
How'd that make you feel?
Like, right.
Yeah, it should have. What are you gonna do about that?
My plan is to make it better and try to give visitations with my children as soon as I get out of here, sir.
Be respectful of the way you go about that.
Yes, sir.
All right. Mr. Corwin, allocution.
Thank you, Your Honor. Guidelines on this are 5 to 34 months. He has 69 days credit. And meeting with him, he acknowledged he's got to stay current on the child support, plus pay back those arrears of $3,667.40. He indicated to me he's going to attempt to get a loan to pay off the arrearages immediately upon his release. I've asked the court to sentence to 5 months in the county jail, subject to waivers, so that he can get out and take care of this, Your Honor. He acknowledges his guilt on this. He pled to the habitual, only had 1 count dismissed, and I would ask the court to consider releasing him today. I do believe, I know the last drug test was slightly dirty, so I would anticipate, and I think that was over 4 weeks ago, that he would be clean from any testing henceforth, Your Honor.
Thank you, Mr. Corwin. Ms. Messer for the Attorney General's office.
Yes, Your Honor. Ms.
Slightly dirty. That's something. I think I'm going to use that. I'm just slightly dirty.
Baker is here and would like to address the court.
Oh, very good then. If you gentlemen will have a seat, the court will hear from its victim.
Thank you, Your Honor.
Yeah, come on up. Good morning.
Morning.
You're Miss Baker?
Yes, I am.
Thanks for coming today.
You're welcome.
Okay, what would you could pull that microphone right up to your mouth so we can hear you. Thank you.
I just want everybody to know that I have given this man many chances. I've even picked him up from prison after his boot camp stuff and bought him a phone, a TV, everything, and hooked him up so he could see his children. And he refused. He gets back on drugs every time. It's same thing, different day. And his daughter has reached out to him. His oldest son has reached out to him. He has ignored all his children for the last 2 years, to be exact. The last time I heard from him, I was asking for help with school stuff. I was like, you don't have to send me money. Just go pick some stuff up and help me out. He put me through this runaround game with his PO at the time. And that's the last time. And then the only time he has ever made any type of child support or any type of help at all is when the courts are making him.
When he's trying to get out of jail, right?
Correct. That is the only time.
Okay.
And his girlfriend made the last payment. He didn't make no payment. He ain't got no money. He ain't got a job.
That $1,500?
Yes.
So do you want? I'm sure that the balance would be welcome to.
I told you. Ladies love bad boys. This guy's rotten to the core. He's got a girlfriend paying his wife. I mean, it's wrong, but it's hilarious.
If I was to abandon my children the way he has, I'd be sitting in prison.
Okay. All right. How are your kids doing now?
My kids are great. They're in private school. I had to put them in private school because of the other case with Dakota Place, which he called CPS on me for. And Ingham County called me, the police station, and said that they were making calls on to CPS trying to get me for that.
Oh.
I was like, well, that's an already ongoing case for over 2 years now. And not to mention my daughter's in therapy.
Okay. So there's a lot of issues outside of this child support case, aren't there?
Oh, yeah. His girlfriend's been nonstop harassing me. I have to block many accounts on Facebook, TikTok. She took my daughter's picture and put it on TikTok and was making fun of her teeth and said, if I can afford to get my nails done, then I can afford braces.
We're really getting way outside.
I'm sorry, Your Honor.
No,
I'm just.
You just want to vent? You can vent.
I want to do more than vent.
I know. Well, if there's harassment, you can always seek a personal protection order,
Yeah, it's a waste of time, Your Honor.
It's a what?
It's a waste of time.
A waste of time?
Yes, because I had a protection order on him a while back, and he still show up.
Okay. Is there anything else you want to say?
No.
Well, thank you for coming today.
I appreciate it. Thanks for hearing me.
Very welcome. All right. Well, the court heard from Ms. Baker. She's clearly not happy with Mr. Baker. Gentlemen, would you join us at the podium? Ms. Corwin had finished allocution. The Attorney General will be up next. Ms. Messer.
Thank you, Your Honor. I don't think I could say it better myself than what Ms. Baker said here to address the emotional and financial struggles of this family with the refusal of Mr. Baker to act as a positive and consistent parental figure in the family's life. The focus, I think, going forward, and I'm going to ask the court to adopt the recommendation of 36-month probation, regardless of the reduction in the arrearage, because I think Ms. Baker is 100% correct that when he's getting the cuffs slapped on, that's when he starts making payments and becomes an active participant in the financial support of his children. There is an ongoing support order. So he's going to have to prove each and every month that he can follow the court's order and make his support payments as ordered, which he's failed to do many, many times. So I think that's going to be the focus of the court, getting employment, getting an income withholding order in place at a reputable place that has a W-2 job, so the money can be taken right out and they don't have to depend on Mr. Booker to pay when he feels he wants to or right before he goes to jail, I think will be the focus. I'm going to ask the court to adopt the recommendation and place Mr.
That's not going to happen.
Baker on probation with the understanding that he does have some pretty significant guidelines. And should that arrearage not have been reduced as significantly as it was, I was going to ask for a trip to the Michigan Department of Corrections.
What's your recommendation for incarceration today, Ms. Messer?
Your Honor, is it my understanding that there was a recent drug test that was negative, or have we not tested Mr. Baker in some time?
I gave up. That was weeks ago. I'm sure he's clean now. I think he would be.
One would hope, Your Honor. I will leave that to the court's discretion. I think Mr. Baker needs to get himself a job and start paying the money. So the best way to do that perhaps would be to stay for a little shorter time in jail than I would like him to. But leave it to the court, Your Honor.
This guy's not going to get a job.
Mr. Baker?
Yes, Your Honor.
What would you like to say?
I do have a job. It is documented with downstairs that I am working at Complete Scrap. I still have my job as soon as I get out. I have reliable transportation and I will complete everything, probation, and I will stay on my monthly payments and pay off the $3,000 that I owe.
Anything else, Mr. Baker?
No, sir.
Well, I've got competing balances here. You've got the mother of your children is here, and she's hopping mad.
Yes, sir.
Very angry.
And I would like to apologize.
Well, you're not here to apologize to her. You're here to be sentenced. But I did hear her, and she's mad. A lot of her issues go outside of what we're here for today, but I hear her, and she's not wrong. She's definitely not Father of the Year.
Correct.
And she's right too. You only pay when you're about to get the cuffs put on you.
Definitely not Father of the Year.
Mr. Baker, you'll be on probation for 3 years. During the course of your probation, all the terms and orders that you said you read and understood are now orders of the court. You'll have some financial obligations you'll need to meet with us. That includes a crime victims assessment of $130, a supervision fee of $30 per month, court costs in the amount of $961, and $136 state cost. And I'm going to pause for just a second, ask you gentlemen to have a seat, and I want to hear from Ms. Baker one more time. Come on up. Welcome back, Ms. Baker. So you're the victim, right?
Yeah.
And the
Or like the children, but yeah.
Well, you are, because you're supposed to receive the money to take care of your children. And the court has options. It could incarcerate him, more time in jail, or even the Michigan Department of Corrections, or it can let him out and he can pay. What would benefit your family more?
He ain't been around this long.
Well, no. I'm not inviting him back into your life. As a victim, do you want
I like her. Keep him in jail. I don't care.
to give him the opportunity to pay you, or
No,
you do not?
I'm sick of giving him opportunities. He's gotten opportunity after opportunity after opportunity. I'm done. I'm fed up. And the way he acted the
I love it.
last time we was at court and just looked right through me, and I asked him about, why have you ignored your children for 2 years? Just looks right through me. Not even at me. Didn't say nothing to me. No, I'm done.
Okay, you're done.
Yep, I'm done.
Thank you.
Thank you.
Gentlemen. Well, hearing from the victim one more time, just to see what her input was for punishment. And what I'm going to try to do is split the difference. I do not think that sending you to the Michigan Department of Corrections for not paying child support would be in the best interest of the family or society, because it's a nonviolent crime. But I do agree with the victim when she says you just don't care. So I think more incarceration would be appropriate. The first year of your probation will be spent in the Shiawassee County Jail. Against that sentence, you'll receive credit for 41 days. That balance will be there for you when you get out. I suggest you get right on it, Ms. Messer.
69 days, correct.
69 days credit. And that'll be 1 year on both counts. They'll run concurrent. You do have some financial obligations. Mr. Schmidt will approach those rights. What I'd like you to do is sign the form acknowledging that you received the same. If you'd like court appointed counsel to assist you with the appeal, you've got 42 days from today's date to make that request. But in the meantime, there'll be child support will be zero. And the victim said, look, she's done, but that balance will be there when you get out. Thank you all very much.
Thank you, Your Honor.
Thank you, Ms. Baker, for coming today. You're very welcome.
All right. I did a video a couple days ago. It was fantastic. It was a Karen with blue hair who's involved in the throuple and making corn videos on her phone. I mean, it's a nightmare. And it got set over for today. We don't really get to see it, but I will show this just so you can see what happened.
Right. I think when we adjourned the other day that we had the paternal grandmother on the stand, and I don't think we had gotten to the point where cross-examination had begun. So we need to call Miss is it Cockrell? Is that come up, please? I'm sorry. Turn your microphone on there.
May I have just a bit of short business before we begin?
You may.
Court asked the parties to have drug tests last time we
Yes.
were here, and I have a copy of this.
Has this been shown to, you've got a copy for her?
I've just given her a copy, and Miss,
All right, this is a drug test result for Dylan Boyd, and it was taken, apparently the date of it, if I'm looking at it correctly, was
the 23rd, Your Honor, the collection.
23rd, the day of the hearing. Collection date was the March 23rd, and the test result was negative.
Yes, Your Honor.
All right, we will mark that as an
I'm shocked, honestly. I really am.
exhibit.
May I,
Next in order.
may I also ask, Your Honor, I don't believe Miss
Maybe. I've got
Smith
stuff.
has an objection, but that this hearing not be produced on YouTube. I think there's some sensitive issues that, for the child.
We had, that's fine. We'll stop the live stream and go from there, so.
Thank you.
Okay, so apparently they proceeded on today with that. That probably makes sense, honestly. If you saw it, it's pretty damn salacious. I mean, it's a bummer because I wanted to laugh at it. I did. If you haven't seen that, it's fantastic. There's a throuple. It's a whole situation. It's just plain ugly. All right, I want to throw another one up here. I did just get some more. All of this is from LawNerdsUnite. Zach hooked me up. I don't know how. He's traveling. He still gets it done. That's how he rolls. I got another one right here real quick. I haven't seen it. Let's go.
Lord.
Well, I feel like that's in the state respond to my bill of particulars. He states that
Oh, good Lord. He's got a bill of particulars. He's got a bill of particulars and a big beard. Let's see how this plays out.
the state informed the defendant that he had lawfully been evicted from 1312 Rhode Island Avenue on 10/14. Additionally, the defendant was charged by Bay County Sheriff's Office for refusing to cooperate with vacating the premises. I wasn't charged with no vacating the premises. I was charged with resisting an officer. And I was released on my own recognizance back to that address the following morning. I never. How can somebody release you back to that address? That's what I'm asking. That wouldn't. I got the court order on it. It was a conditional release bond. I wasn't evicted.
That doesn't mean that.
I wasn't evicted, sir.
That doesn't mean anything.
I never was evicted from the property. I was consciously at my house. I thought I was at home. I had no idea I was doing anything wrong whatsoever.
Were they there to evict you?
Your Honor, the defendant has been evicted and a lot of these issues have already been litigated and judged.
I agree that a lot of them is reversed. There was one thing I had a question about.
My name's never appeared on evicted paper nowhere. And my mother, the lights were on in her name. We were not given due process whatsoever. They gave my mom, she had 20 years worth of furniture in that house, and they gave her 5 days to move out and never put her name on nothing. I don't understand it. I would have never went back there without that court order. I promise you that.
That's not that release. That didn't give you a right to go back there. That is.
They didn't evict that.
I mean, it doesn't matter if that's a conditional release. It still doesn't give you if you're legally away from there. I'm not saying
you shall not change your address.
Listen to me. You may have a legal right to be there. That does not give you a legal right to be there, and that's just plain common sense.
I mean, how was I not supposed to know, sir? When they told me
you don't know that, you need to hire you a lawyer. Let me appoint you a lawyer because that is common sense.
But I was not evicted.
Listen to me. If they
You need to hire you a lawyer because that is common sense. I love these accents. I love them.
if you gave that as your address, that's where you're going to be released to. That doesn't mean anything.
I did not give that as my address. That's what was on my driver's license. That was my residence.
Gosh almighty.
Well, how come?
That is the dumbest
How
argument.
about a no trespassing? How about telling me not to go back there?
The dumbest argument. But if you want to represent yourself, you might represent yourself right into a felony conviction, but that is your right to do.
I've offered a settlement already. I guess the state's willing to, because all I want
I always like this judge, but he is on fire today. This is fantastic.
to do is end. I was honestly, I thought I was at home. I went home that day when I was released, and I actually stayed there 7 days. I didn't break in anything. Everything in the home was mine and my mother's.
I guess the only question is what, and I'm not sure the state has to do that at this time, but the only question I think as far as the state in particular is what crime was being committed or what crime was intended on being committed as far as the burglary charge.
How was I committing a crime when I was?
That might be the only issue at this time, but I'm not sure the state has to do that at this, didn't have to, just has to allege. So that's the question. So.
I mean, he's alleging that I went there illegally on the 14th.
Well, I mean, that's.
He also says that I was released from jail after signing the.
That's the question is whether, what underlying, what theory the state's going under as far as what charge was being, what crime was anticipated or intended on being committed by breaking into the house or going into the house illegally.
Yeah.
That makes sense, Mr. White.
It does, Your Honor.
And he also says that I was released after jail after signing. I would not have signed that resisting officer.
That doesn't matter. That does not matter. You may have a defense of this. You just don't know what you're doing. But
Well, I
you
mean-
want to represent yourself, so I'm gonna let you represent yourself. If you had an attorney, they probably could help you, but keep on doing what you're doing. Because you may have a defense. Listen,
Honestly,
you may
sir,
have a defense of the case. I don't know, but you ought to either go hire a lawyer, or let me appoint you one. But if you don't want that, you don't want me to do that. Is that correct?
well, I mean,
No, I don't want to hear, well, you don't want me to do
the
that.
main reason I have not wanted to do that, sir, is because they wouldn't bring up the fact that I wasn't released from jail. I didn't know I was doing anything wrong.
I'm gonna just set it for.
Do you want an effing attorney? He's trying to help you. Oh my God. You keep trying to argue the case. He already told you you suck at it, and you do. This guy's got a great accent, but he's no dummy. He is a sharp judge. I know him.
For a pretrial.
Not personally, but I know what I'm familiar with him. He's a good judge.
Where are we at as far as setting the trial?
Do I get a bill of particulars?
No,
Huh?
no, sir.
With false statements in the.
Listen, when you represent yourself, when I say no, whether you agree, look, there's a lawyers over there, I say no to them all the time and they don't agree with it. Sometimes they probably do, sometimes they don't, but they don't argue with you.
Yes, sir.
Okay? Whether I'm right or wrong.
Yes, sir. Can I ask you a question?
No. Yeah, you can. I can't give you any legal advice.
Yes, sir. how, I don't understand how a charge comes to be.
Can't give you legal advice.
I'm not,
I can't give you legal advice.
just
All I
saying, I
can-
don't
all I can give
understand
you- all I can give you is good
it.
advice is you need a law, is you need a lawyer. But you want to represent yourself?
Can you explain to me how?
No, sir. I
I
can't.
don't understand where the charge comes from
I've
beginning.
already told you I can't. I'm setting this for a pretrial in June due night at 1:30. Whenever you want an attorney, if you want one, let me know and I'll appoint one or you can hire one. That'll conclude today's hearing. Oh, man.
Oh, that was fun. That was way more fun than I expected. All right. It looks like Biggin's not going on, so I think we'll just keep this rolling. I've got one more good one here since it's Karen Day. It's Karen Day, and I got more of them. Let's do it.
We are here in the matter of Angela Taylor versus Paul Colby.
Everyone's favorite, Rossi, who talked everyone into a stupor on the other channel earlier today.
Case number 23-10503PP. And this hearing is being recorded on Zoom and live streamed on YouTube.
And this matter comes before the court. I believe we are continuing a hearing regarding an allegation that there was a violation of the court's PPO. So, Mr. Murphy, would you put your appearance on the record, please?
Yes, Your Honor. Can you hear me okay, by the way?
Yes, I can.
Okay. Yes.
What does she have on her head? And why does she think it's appropriate for court?
Miles Murphy for the respondent, Paul Colby.
Very good. Thank you. And I do see Miss Angela Taylor present as the petitioner in this matter. Remind me, Miss Taylor, the prosecutor is not involved in this particular allegation?
No.
Okay, yeah, I don't recall the prosecutor being here previously. I just wanted to make sure I'm remembering everything correctly because, and I want to apologize to all the parties for the delay in starting today. The previous case involved a giant contract and other matters case with about 100 exhibits that I could barely keep straight in front of me this afternoon and stayed up till 2 a.m. reading last night. And I'm already regretting that investment of my time, but it was totally necessary if I was going to get through this stuff. So that's what delayed me was much longer at oral argument than I anticipated there because of the complexity of that.
I didn't see that case, but my guess is that you talked too long, Judge. That's my thought.
Case. So hopefully we're not as long today, but Mr. Murphy, where did we leave off last time?
Your Honor, we had a hearing about a year ago in February of 25. The PPO is due to expire. The PPO extension is due to expire on April 24 of 26. We are asking that PPO be that it go ahead and expire. We filed basically a denial of any violation of the PPO, and I think it's if the court looks at the volume of this PPO file, it is incredible how large it is. I think due to it's our position. This is a frivolous motion. It should be denied. We're also asking that the court recognize this as being kind of an ongoing, for lack of a better word, manipulation of the system. And really the focus here is the petitioner's displeasure with a Court of Appeals case involving the House, which is going to be.
That has nothing to do with this. This isn't for a PPO violation.
Yeah, no, I get it. I think Mr. Murphy's trying to say.
That's kind of
wasted. Did Miss Taylor or?
Oh, she comes in strong. She comes in strong. She seems like a good time.
Well, let me finish with Mr. Murphy, and then I'll let you have a chance, Miss Taylor. Mr. Murphy, did we take any testimony during that last hearing, or did I just set a future hearing?
Sure. You did take a lot of testimony in February of 25, Your Honor, and then the other focus besides the House is the fact the parties have a almost 18-year-old son, and my client has sole custody, and I don't think the petitioner's happy about that either. So we ask that the
He doesn't
Motion.
have sole custody.
Excuse me,
I have
ma'am.
custody
Okay,
too.
no, hang on, Miss Taylor. I'll let you speak up.
Great,
All right,
yep.
Miss Taylor, I do recall now, and I'm paging through the file here, and it looks like I did take significant testimony about the allegations. Did I swear you in and have you testify last time?
Yes.
Your Honor.
Okay, and then Mr. Murphy cross-examined you?
Correct.
Yes.
Okay. Is there, I guess since this is your case, Ms. Taylor, are there any more witnesses or evidence you want to provide at this time?
Yes.
Okay, who would you like to call?
Robert Goins.
Okay. And is Mr. Goins present? Is he with you or is he separate?
Yes,
Is he gonna
he's
come
my
in?
tenant.
Okay. And is he on the same video as you are? Are you just going to switch it so he can testify or?
Yeah, I can switch it. I can turn it around so you can see him.
Very good. All right. That would be good. Why don't you do that? I'll swear him in and then you can ask him the questions, Ms. Taylor. Mr. Goins, would you raise your right hand, please? Do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes, Your Honor.
Thank you. And would you state and spell your full name for the record, please?
Robert, Robert, Goins, Goins.
Thank you, sir. And you don't have to keep your hand up anymore. Ms. Taylor, you can ask some questions of Mr. Goins at this time.
I just have a question a minute, Your Honor, if I may.
Go ahead.
This wasn't a trial hearing. I'm confused on why this has jumped to a trial when she was not prepared for a trial.
Well, I mean,
this was just a conference hearing on his PPO violation.
If I could respond briefly, Your Honor, I believe that it's teed up as a motion for an order to show cause for a violation of the PPO.
Yes,
and
correct.
So
well,
I
and
do
my
believe
sense
that-
was that I'd already inquired of Mr. Colby about this, that he pled not guilty, and that I
Nope.
set it for a factual hearing. And
No,
it was-
sir.
Oh, okay. Well, and believe me, I could be wrong on this because I handle about 1,000 cases at any given time, and to say that I have a hard time keeping them straight mentally, I'm completely dependent on my notes in the file here.
So, Your Honor, I
Okay.
think the focus is on several allegations about a February 12 of 26 Facebook posting. That's what Angela did not like. Is that correct, Mr. Goins?
There's several Facebook postings, stalking, where he's followed us to a library, and then posted it where he's come to the home and he's making statements in regards to how many FedEx and Amazon comes to the home. That's showing that he's stalking. He posted that on Facebook.
So, Your Honor, they're all very recent allegations about conduct in
here
February
we
of
go.
26 as allegedly violating the PPO, which is due to expire in a month.
I see. And so really what today's is simply the order to show cause, where I would obviously inquire of you and your client whether you wish to enter a guilty or not guilty plea, and then presumably set a future hearing to do the facts on this. In other words, I was about to skip a step.
Correct.
I think that's correct, Your Honor.
Okay, no, fair enough. Well, I take it, Mr. Murphy, from your previous statements, your client intends to enter a not guilty plea to the most recent allegations of violation.
That is correct, Your Honor.
Okay, I will accept a not guilty plea in the matter, and I will set it for a hearing. Now, the bad news for you is the other consequence of these 1,000 cases I have is this hearing will undoubtedly occur after the expiration of the PPO. What's this? Well, I mean, first of all, how many witnesses, Ms. Taylor, do you think you're going to be presenting?
2.
Yourself and Mr. Goins?
And I have one more.
Okay, so up to 3. So I'm going to guess that's going to take us a couple hours by the time I give Mr. Murphy some opportunity to cross-examine and time for argument here. Wendy, this is a hard question. When's my next 3-hour block that I could set for a PPO hearing?
Well, we can do May 22nd at 2:30, but
Not as bad as I thought. Let's grab that time while it's available. May the 22nd at 2:30 p.m.
Also, Your Honor, Ms. Taylor also filed a renewal of her PPO, that you
So that-
didn't, state anything on that as well.
Yep, no, I am looking here. Let's see. I see, boy, the violations and all the accompanying notices. Let's see here. I did get the oh. There's the extension. Yeah, and I did extend it. It looks like obviously back in April of 2025 to, as Mr. Murphy correctly pointed out, April 24th of 2026.
And then she just sent your office with the PPO office a renewed and got a document back saying that you stated that you would after this conference hearing or when it gets closer to that expiration that you would then state whether you were going to grant
make a
it.
ruling. Yeah, that's what I usually do if I have an upcoming hearing. As I said, you know what, I'll decide it all in one hearing. In this matter, because I'm not able to push that, what I'm going to do in this matter, since it's my schedule dictating here, is I will grant a temporary extension until that date of the hearing that I just sent, May 22nd. That's only 1 month from the expiration date anyways. And, Mr. Colby has been obeying the order thus far. And then I will decide both the question of the extension and also, and
I object because
Ma'am,
Mr.
you're
Colby is
interrupting.
yeah, I
You're
don't have
interrupting the judge.
the extension just has not made its way into the request hasn't made its way into my paper file. It's probably in our electronic court filing system. I'm just flipping through the paper file that I brought home. When I get up to speed on this, I'll be able
I want to hear more from her.
to review the extension. And then I think, my sense is I can decide that all in one hearing. Do you agree with that, Ms. Colby?
Yes, yes, I do.
If he comes on this property, I will kill him. That's simple.
Ms. Taylor, do you think that I can decide that all in that single hearing in May?
I don't know because he keeps violating his PPO. I have to be worried to even walk out of my house. I have to have somebody walk me out because he's constantly stalking. No, this needs to be addressed. He needs to be violated for this. If he comes on this property, he probably ain't going to make it out alive because the cops take an hour and 45 minutes to get out here.
Totally disagree. Your
Well,
Honor.
yeah, and my only counseling to you on that, Ms. Taylor, and I get
That
it,
Murphy
right?
really has nothing to do
No.
with this PPO violation.
Well, no, and he's representing, Mr. Colby for the purpose of the PPO hearing here, and it's important, obviously, because Mr. Colby's the one, as I've explained to him in the past, who's at risk when one of these is in place against him, and if you
And nothing gets done about it.
well,
He's
if you
already
all I can
violated
say is I have
14 PPO.
Well, I have, and I believe there was one case in the past where I fined him a couple $100 on a violation, and I think what I'm hearing
That's
from you
just a
is
slap on his hand.
okay. Well, but nonetheless,
So if I come up missing, it's okay.
no, of course not. But that's not what's before the
Something
court
needs
now.
to be
so,
done.
Your Honor, we'd
Yeah.
ask that she be
Yeah, and here's the thing is
handcuffed.
what's done is
I'm
the
not talking
enforcement.
to you,
Yeah.
Mr. Murphy.
Yeah, is the enforcement of this thing, and I do want to mention to you, Ms. Taylor. Obviously, this isn't it's going to be a formal court hearing, and this is today as well, where we got to speak in sequence. It's not an argument per se, or us sitting at the table to hash something out. It's a very formalized and recorded proceeding where both parties have the right to appeal after I decide it. So it's important,
Your,
you know. to
Your
do it
Honor, I just want to state,
procedurally.
to you
Mr.
that
Goins, I'm
Ms.
not, I
Taylor,
don't want your statement because you're not a party, so you're out. So you just have to stay quiet. You want to file your own PPO?
You
Go ahead and
shut
file it.
your hole.
But,
He did,
you're
Your
not a
Honor. It
party
was
to the one
denied.
that's currently before
Still
the court.
going.
So anyway, that's what we'll do. We'll hold the hearing. The PPO does remain in place, and of course,
It's pure chaos. It's just a three-ring circus.
parties are familiar with the terms of the PPO until such date that I will conduct the hearings. So I will see everyone on May 22nd.
Thank you, Your Honor.
Thank you,
Thank
Your
you.
Honor.
Okay,
This one here, Zach got it for me, of course, but it's Alyssa's fault. She said Rossi's at it again, and both hearings are good.
on to our next one.
That's going to be a great one, isn't it, Wendy? You're really hoping Lisa's back by May 22nd.
Yes.
I can sense it. Okay, well, as if not right. Okay.
Okay, next is the matter of Gonzalez versus Gamboa, case number 26-30243-PH. This hearing is being recorded on Zoom and live streamed on YouTube.
All right, and this matter comes before the court today on the respondent's request to terminate a protective order that I granted. It looks like application and the order. Looks like I granted it on March the 4th of this year. So, and it does appear that both parties are present. What I'm going to do at this time is have both parties state and spell their names for the record, and then I will take testimony from the parties and make a ruling on whether or not the protective order stays in place. So, as an initial matter, Ms. Gonzalez, you may go first if you would state and spell your name for the record.
Jasmine Crescencio Gonzalez.
Could you spell it, please?
Yeah, Jasmine, and then Crescencio, and then Gonzalez.
All right, thank you, Ms. Gonzalez and Ms. Gamboa.
It's Samantha, Samantha. Middle name Sarai, Zaray. Gamboa, Gamboa, hyphenated with Godinez, Godinez.
Okay, and would you prefer to be referred to as Miss Gamboa, Miss Godinez, or Gamboa Godinez? I can do any of the above.
Gamboa is fine. Thank you.
Very good. I'll continue with that then, and I have to step away from the bench for just 1 second here.
Okay, that's
And
fine.
I will return in about 5 seconds, so thank you.
Alrighty.
Piano lesson occurring in the back in the hearing. I apologize for that delay. I am proceeding by Zoom from my home office today, and we have a piano lesson occurring in the background for my kindergartner. So if you hear sweet noises, that is my 7-year-old singing. So all right, this case was brought by Miss Gonzalez. So I will swear you in, Miss Gonzalez, and have you affirm the basis, and then I'll hear Ms. Gamboa's response to that, and then I can make a ruling. So, Ms. Gonzalez, if you please raise your right hand. And you're gonna have to unmute as well. Okay, very good. And do you solemnly swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
Very good. All right, Ms. Gonzalez. You filed this protective order, which I granted, and the basis you stated in your petition was I see. She has been harassing me since last week, February 23rd of, I assume that's this year, 2026, and had threatened me with her firearm and threatened my family. Can you describe more specifically how that happened?
Yes. So,
Ooh, this is juicy.
I had a confusion today about like the Zoom meeting. I thought this was gonna be in person, and I did have some evidence that like I wanted to present documentation of like statements that the respondent has said, and I think it's important for the court to review before like deciding whether
I think it's important for like the court to review.
to terminate the PPO.
Okay, and are those like printouts of text messages? What kind of documents do you have that you'd like me to see?
Yes, they're printed out screenshots of multiple messages that I received from the respondent. Yeah. I was gonna present them today, and I went to the court. But I was
Only
told
to
that it was
find
gonna
out the
be
hearing
through
was
Zoom.
on Zoom. Yeah, I do all my PPO hearings on Zoom because the court rules allow me to. Either party, just for reference, can request to have the hearing in person instead. The truth is I can get a lot more of these hearings accomplished if I go on Zoom, so I prefer to do it that way. And sometimes it's easier for the parties than getting down to the courthouse and parking. But I am more than willing to do them in person. I guess for purposes of today, Ms. Gonzalez, can you? You need to come up with 2 incidents of threats that she made to you. If you can read out loud what she allegedly said to you during those messages, then I can let Ms. Gamboa respond to that as to whether or not she really sent the message or not. And then maybe I can get far enough to make a decision today. I may still need to have you come in. So is it possible to read some of those?
Yeah, I have a total of 28 pages.
So it's a lot.
Yeah, it's quite a few.
Did you
But
submit
there
them to
is
OnBase or to the court ever? Because we do keep it.
no.
Okay, I was just thinking maybe I could pull them up if they were electronically in our file, but if they haven't, come through the door yet, then, I won't have them available to me yet. Well, why don't you go ahead, and these are.
I picture 28 pages of handwriting where all the I's are dotted with hearts.
Messages that came to you before you asked for the PPO.
Oh, good Lord.
On March the 3rd that were threatening. Do some of the messages threaten you with her firearm?
Yes, there was one message, and she said that I was going to get taken off the map, and also that she stated that she carries 2 firearms.
Okay, what's the date on that message, if you can tell?
These were in March 3rd.
Okay, same day you filed the request for the PPO, it looks like.
Yes.
And how do you know those are from Ms. Gonzalez?
Because she's messaged me through a personal account, and her name is on there as well.
Okay, so it says, what is it says, Jasmine Gonzalez, or what does it say? Or, I'm sorry, how do you know you're Miss Gonzalez, how do you know this is coming from, the respondent, Miss Gamboa?
Is it okay if I can turn the camera around and just
You can
show
try
you?
that. Sometimes we can see it if you do it like that. Okay, I'm seeing what looks like a printout, and you're saying it says right on the top there, Samantha Gamboa.
Yes, that's Samantha Gamboa, and then this is the comment that she made about threatening me.
Yep. And is that coming
And
in by
then
a text message to you?
yes, this is all these messages are through Facebook. And
Okay.
then here's another one where she said to be careful coming out of my house. And I have proof that she knows where I live, but I have never once told her my address.
Okay, and how do you know she knows where you live?
Because then she went onto my Facebook, and you can see here Samantha Gamboa commented on my status, and it says my address right here.
Okay, all right. So she, it appears in the comments on your Facebook page, wrote down your address.
Right. And she my pictures with comments about my address.
Okay, that's not good.
Okay, and taken in conjunction, where's the message that you said she sent you that said she carries 2 guns?
Right. This is right here.
Okay, and that says, love you should now I carry 2. Is that right?
Yes, I think she meant instead of saying now, she meant to say no. So love, you should know I carry 2.
Okay, all right. Well, all right. So, and what you're saying here to me today in your testimony is that the combination of those messages and her knowing your address created what you perceive as a threat.
Yes.
Okay. All right. Is there anything, now you said you had some 20 messages there. Are they before or after the ones you just showed me?
So the ones that I showed you beforehand were back in March 3rd.
Yeah.
Yeah, and then she's also just been posting my address all over social media.
I see. And what you're showing me now on the screen looks like it's dated March 3rd and it's the photo of a
I see no evidence of this yet, but I can't imagine this happening without a guy being involved somewhere.
front of a house. Is it your house?
Yes, that is my house, and she's posted that on social media. And you can
And it
tell
says
here.
when you played too much, what is the next part of it? I can't quite read that.
It says when you played FBI too much, Stank needs a whooping.
Okay. And that again is originating, you believe, with Miss Gamboa going to you.
Yes.
Okay. All right. And it also occurred on or about March the 3rd when you asked for the order.
Um,
I mean, they are Latinas.
I would also like to show you
Take that as you
something very
will.
important, because whenever she has served those papers right back to me, terminating them, she's also, I've read the note where it says she's pursuing a nursing career.
Yep.
And I would like to just put this out there that she somehow, I have no idea, found out that I was in Pine Rest hospital for a while. And if my sister, she told me that that's exposing my health information, and it's going against HIPAA regulations, which is made to protect everyone's health information. And
Did she mention the fact that she stated that you were in Pine Rest on this same exchange? I mean, is this on some of these messages?
yes, so she's also made she's messaged me that right here where it says Pine Rest as ho. And
What's the date on that
after
message?
that, this was March 4th
Okay, so
at
after,
7.
yeah.
Yes, this
So
is
that'd be
after.
after you applied, maybe after she got served, after I signed it and issued the order.
Yes.
Okay.
And then she's also made a fake page about me impersonating me and putting my health information out to people to know, which that says here in the comments.
Okay, what's the name of the page that's impersonating you?
It's called Jazz GR Community 8.
Okay, and how do you know that
But
Gamboa made it?
right. So it says here, sorry. So whenever she's got served, which was 3/9/26 at 3:49 p.m. This is a confirmation picture of the PPO being served
Yeah.
and signed off. Keep in mind that was on the 9th.
Yeah.
And then this is the account that she made. She's had 522 followings and quite a like 56 postings of me. And the reason why I believe that
Can
it
you
is
tell
her
when she
is
created, I'm sorry to interrupt, but can you tell when she created the page or the account?
no, that one I couldn't take a screenshot and print out, but right after she's got served, I did receive a message from a friend of mine saying that the page did not exist anymore. And this was the day after she got served, which was March 10th.
Okay, so really you don't know for sure if she created that before getting served with the PPO or after, because you just can't tell from the Facebook page.
It was an Instagram page, but I'm more than confident to say that it was her because the comments that she made on all of these postings is something that she's already said to me in messages directly.
But you can't tell when she posted it. It doesn't have a date.
Like a posting.
Yeah, any date identifier, and it's important because the stuff that happened before is the basis for your protective order, and then things that happen after, if I continue the protective order, you can raise them as violations potentially, but they can't support the protective order because they didn't happen until after I signed the protective order. So that's the importance of the date.
Right. This see this picture? This was on the 4th.
Okay, which would have been golly.
The same one she posted on that fake page.
Yeah, which looks like maybe she was served with this on the 4th because I think that's what the proof of
Yes.
service says. Yeah, okay. Well, that's the date I signed it, and right, she could have been served with it that same day. So, okay. No, I think I understand what you're saying, and it sounds to me like what you're identifying the two threatening incidents being those messages on the 3rd that say, I think you should be taken off the mat. Stank needs a whooping, and I carry 2. Those were the threatening messages in conjunction with her identifying your address that that spurred you to get this PPO.
Yes.
Okay. All right. Well, let me give Ms. Gamboa an opportunity to respond. So, Ms. Gamboa, if you would please unmute and then raise your right hand. Do you solemnly
Yes.
swear or affirm that your testimony today will be the truth and nothing but the truth?
Yes.
All right, thank you. And Ms. Gamboa, you respond to this asking me to terminate it.
Correct.
Apologize. Here I'm paging through the different filings and submitted a letter. And I take it from you, I'm reading down in your letter here. That prior to the incident, the petitioner communicated with me directly and provided her address, I take it, encouraging a confrontation. And that then, I mean, I guess what I'm trying to get, Ms. Gambo, is what's your version of what occurred? It sounds like from saying that maybe you're saying, well, she started it.
Your Honor, I take this situation very seriously. I understand the purpose of a PPO order. However, I believe the situation was a mutual and not one-sided. The petitioner also engaged and used aggressive communication and encouraged a confrontation. I provided you with evidence. I'm currently focused on my education and pursuing a nursing career as a nurse anesthetist. I almost didn't have time to make it today. My schedule is super busy with school and work. But yes, I did provide you with some evidence that she provided addresses and told me to come, and I did not go. So I believe that this was mutual. I've never seen her in person. I never met her in person. We don't go to the same places. We're not in the same circle at all. So therefore, that's why I asked for this.
Okay. Well, yeah, you're asking me to terminate it now, but you're not denying. Did you post the messages she cited about I carry two and Stank needs a whooping?
Yes, I take responsibility for my part, but like I said, it was a mutual exchange. Ever since then, I blocked her and I don't have any intention in having further contact or arguing or doing anything of that sort. I just want to move forward.
Okay, and I take it you're saying that the confrontation, because what I'm looking at here is the documents that you submitted objecting, and there's this page popped ass peasant. Are you saying is that your page or is that
No.
Okay, you're saying that is
That's her.
her. Okay.
Yes.
And these are exchanges, and I'm looking here, March 2nd at 8:04 a.m. I'll be solo, pull up though, IDGAF, 3 p.m. Aha, never gave scary or pussy watch. Yeah, right. We'll see, fat F. You're a peasant. There's back and forth going, and I think what you're trying to tell me is that on March 3rd, when this conversation continues, it's simply an escalation or a continuation of a verbal or online electronic back and forth that had already been started.
Correct. But after that, like I said, we blocked each other. I blocked her, and didn't have any contact with her.
Okay.
And I was served. I know you guys were talking about that earlier, and I was served the 9th. I wasn't served that exact same day. I wasn't served the next day. I wasn't served the next day. I was served the 9th.
I see. So you didn't even know that there was a
No.
protective order against you until it was delivered to you. Yeah, it looked like I maybe signed it on the 4th. I don't have the proof of service here. Okay, all right, and
In your honor,
yep.
this is, like I said, this is very, very important to me because I mean, this is my career that I'm talking about, and in the heat of the moment, I was upset. But I learned and I grew from this experience, and it was a very tough time, but I don't want to go through it again, and nor do I want this on my record.
Yeah, no, well, here's the good news for you. These are civil matters. They don't ever show the only time they would show on any government record is if the police run a lien check because they come to a call, alleging a violation of one of these things, they can see that the order exists. But when the order expires or is dismissed by me, whatever, it goes away. And unlike a criminal record, which is recorded, by the state police in our, the database, this
I hope you know that this will go down on your permanent record.
does not remain there forever. It's unlike that, in other words. And employers can ask you if you've ever been convicted of a felony, but generally they do not ask you if you've ever been subject to a protective order, things like that. And that's because they are civil matters. They are not as serious as a criminal matter. Now, I don't want to downplay it. If I put one in place and it stays in place, well, then you can get charged with a felony aggravated stalking for violence.
Get on with it, Ross. See, I already listened to this one up talk for a while. The second one's not so bad. She actually makes sense.
Violating it, and it can get you in a lot of trouble. But the other piece of it is even in a worst case scenario, when I grant these and they stay in place, and the reason I typically grant them for 6 months is recognizing that a lot of times when people see these and legal documents start being exchanged, all of a sudden both people say, you know what, it's not worth it anymore, and kind of back away from the situation. And that may have happened here, and in that case, it kind of satisfied the the intention of the order. So and I hear what you're saying is whatever you do, Judge, I don't want it to interfere with my future career aspirations. Where are you in that educational process now?
So I'm very excited to start in winter for my nursing program, and therefore I do need to submit a background check for that. That's why I'm like very, very, very serious about this. I do
Sure.
have a whole plan. I'm sorry.
No, and you said winter. I mean, so I'm taking it fall next.
So this hearing does confirm what all men think about Latinas. In a nutshell, I'm going to tell you. I'm going to be this honest. It's happy hour. I'm going to tell you the truth. You already know this. But all men, when dealing with Latinas, think, this could be a lot of fun, but I might die.
Winter or this year?
Yes. Yes. Basically next year. Yes.
Okay, so in the fall term,
Yes.
that would be when that would start. Oh,
Correct.
okay. I understand. I don't think this is gonna even touch that because of its nature, but nonetheless, I do understand your concern. Let me return to petitioner in the case here, and hear from Ms. Gonzalez again. Ms. Gonzalez, you said you saw the letter. Did you see the attachments to the letter that under this Popdas peasant webpage or not? So webpage, maybe a Facebook profile. I'm not sure what it is. Apologize for my lack of social media currency. Did you see those attachments?
Yes, I seen them all.
Okay. And I think what Ms. Gambo is arguing today is, look at Judge, I did say stuff that I now regret. However, it was in the context of this back and forth online that what was a back and forth, and that it looks like you're responding here too, and saying, things back to her. What's your response to that?
So there was a point, where she kept messaging me and I told her to leave me alone. And she kept going right after I said that. Yeah,
Okay.
so I told her that she was annoying me. At that point, she was just going to get ignored. And she then proceeded to text me after I blocked her on Instagram, this is Instagram.
Okay.
After I blocked her.
And when you're saying this, you're referring to the documents that Ms. Gamboa attached screenshots of to her letter. So, is that what we're all talking about here, this Popped Ass Peasant series?
Yes.
Okay.
She then proceeded onto Facebook. So I
Popped ass
honestly,
peasant.
I don't believe that she would, not keep going after this because
I'm not gonna be happy unless one of them says that the other one is chopped. I need it. I need it before this hearing's over.
she had only deleted that Instagram page because she found out that she was getting served with the PPO. Otherwise, she would have kept posting because I have a video recording of the entire page.
Wait, I'm between that. There's so many good ones here. I'm between that. What did she say? Oh, what did she say to her? I don't know if I can get away with the ass on my thumbnail though.
Made about me, and it says the dates and the timing.
What's
So
the-
every day
What was the one with the whooping? Stank whooping or something?
she would make a posting about me.
Okay. And,
Yeah.
and all around the
Skank
same
needs a whooping.
time frame of March of this year.
Yes.
All right. Do we go skank needs a whooping or popped ass peasant?
Okay. All right. Well,
And I also do not believe that it's okay for someone who is in a nursing career to put my information about me being.
Oh, it offends your sensibilities for the nursing board, huh? We don't care. I mean, you make a good argument that she threatened you, which is on point. If you ask me, she said some nasty stuff. But your perception of what the nursing licensing authority should do is absolutely irrelevant.
In Pine Rest Hospital out for the public because that is violating HIPAA regulations.
well, certainly could, and I will say certainly, that's the kind of information that qualifies as harassment, and that's what about these protective orders is the essential goal of the protective order is to keep the two parties apart from each other so that things don't escalate to being, hey, meet me at such and so an address, and they turn into a fight or a gunfight or a knife fight or anything else. The law's desire in this thing is, I sometimes say it's kind of like a boxing match or a kickboxing match where the referee says to the two people that are fighting, hey, you two get back to your corners and you just stay there. No swings at the other person, just stay in your corner and let this thing cool off a little bit. And, that's what, anyway, we hope they do. And
oh my God. Seriously? You need to tell that? You need to tell that story to explain that concept? You can launch into the kickboxing sport of the future speech now?
It sounds like it might be working here, but the facts that were testified to today before the court and establish that, on or about early, late February, early March of this year, that there was an exchange, maybe several exchanges between the parties here on various electronic platforms, including, apparently Instagram and Facebook. And the plaintiff responded by, or the petitioner here, Ms. Gonzalez replied by filing a request for a protective order, stating that she had threatened me with her firearm and threatened my family. She has found where I live and has been posting my address on social media. And just now she's been texting me and told me she is outside my house. I do not feel safe, especially when I've been threatened countless times with her firearm. And to support that, yeah, the court was shown messages today that did indeed say, threaten to take you off the map and know that I carry two, which, perhaps in street language, certainly, when we refer to carry, I take that as perhaps you're exercising the ability to carry a concealed weapon and doing so. Given those messages and then subsequent messages that do say Stank needs a whooping, with a picture of the house where the petitioner, Ms. Gonzalez, lives.
I mean, does there have to be a song? Stank needs a whooping. I don't know. I can't imagine that there wouldn't be a song called Stank Needs a Whooping. I
certainly can.
I don't want to live in a world that doesn't have a song titled Stank Needs a Whooping.
See where, in a reasonable person's mind, that would be considered threatening. Now, Ms. Gamboa has appeared today and supplied additional messages to the court and also a letter saying basically I'm not maybe the crazy person depicted by these exchanges here, but rather, Judge, I want you to understand this was in the context of a mutual exchange online where things got heated on both ends. And I agree that it was. However, I do have to recognize that Ms. Gamboa, it was you that escalated this, with saying you carry, implying a weapon and also posting the address, which I didn't see in the other messages that you posted that, she was outing your address or doing those things. There were threats, back and forth and shut up and name calling and things like that going back and forth, but not, it escalated when there's a threat of a weapon. So I do think that two incidents occurred online in this case that would justify continuation of the protective order as it's written. And after all, protective orders don't, they're not major limitations on your life except with regard to the protected individual. And secondly, with regard to purchasing or possessing a firearm, they do limit your ability to have a firearm in your possession during the time that the protective order is in place. Because the threat here is about carrying, I'm inclined to leave that firearm provision in here. I am going to allow the protective order to continue at this point. As I said, I write these for 6 months, and this one therefore expires, I think, in September. Or the expiration portion of it. Yeah, expires September 3rd of next year. So this will expire about coincidental with the start of that nursing program. I would counsel you, Ms. Gamboa, you do seem to be, a person who thinks about the future and things like that. This falls into a broad category of things that are simply not worth it to mess with the protective order while it's in place. Just the definition of contact in here, because it does say you can't contact the person by telephone or send mail or other communications to the petitioner. While the definition of contact is very broad because it references another Michigan statute, which basically says if you post on social media or if you send something to someone else on social media and they're going to forward it to the person, with the intention of getting their attention, that can be construed by me as you contacting them. And the way that happens, if Ms. Gonzalez feels like you violated that by something that you posted or something stated online, is that she would bring a alleged violation in front of the court, and then you'd be entitled to a hearing as to whether or not whatever was posted did violate my protective order. And I always tell people, if I do find that you violated, the penalties there are up to 93 days in jail and a $400 fine. So it's way easier just to say, okay, we're going to take that neutral corners at this time and not have any contact with each other. sometimes these people that file these live like, you guys aren't like neighbors, are you? Like not right next to each other, or, I mean, I do know you both have Northwest addresses, but it doesn't sound like you would run into each other every day walking your dogs or anything like that. So, I tell most people it should be pretty darned easy to obey the terms of a protective order, because it basically says, obey the law, don't pester this other person for 6 months. And as it comes up to that 6 months, if Ms. Gonzalez feels like there is a basis for continuing the protective order, and that basis the law defines as another violation of the protective order that occurred between now and then you can ask to extend it, or it just automatically expires and I remove it from the lien system and it is no longer an issue. So that's what I think both parties' goal ought to be here. There was a online blow up. Fortunately for everyone, it didn't result in any sort of physical confrontation or anything else, because it's always worse. And I always applaud parties for turning to the court and saying, hey, you know what, I'm angry about this, but I'm going to handle it essentially by filing some paperwork rather than by actually going to your house and knocking on your door in the middle of the night or something along those lines. So it is a preferred way of resolving things, even though it's not perfect. So any questions from me from either petitioner or respondent? I'll give you the first chance, Ms. Gonzalez.
So, I guess I just want confirmation that the PPO will remain in place.
It will remain in place till September 3rd of this year.
Okay, thank you.
Thank you. And Ms. Gamble, any questions for me at this time?
No, I just want to reassure you that I did not make any contacts to her since I received the PPO order. I just want to make that very, very clear.
No, I appreciate that. And I don't have any, allegations.
Actually, through all this, I'm having fun at their expense a little bit. I cannot stand the way the first one talks, that speech pattern. But other than that, she actually had her stuff together and she made sense. And I do think that the other one crossed the line, so I understand why she was asking for it. And then the other one, who sort of admits that she crossed the line, says, I'm not doing it anymore. And she was so upfront, I actually believe her. So whatever, I'm having a little fun, but ultimately they're not the craziest people I've ever seen. I kind of see where they're both coming from.
That you violated yet, and of course those would all come up after you've been served, and you identified that service date as March the 9th. So that's when that takes effect regarding you, is when it's actually in place. And I'm grateful that you didn't, like I say, you've got everything to lose the way the PPO works if you violate. So even if something does bother you, or you think someone's trying to get under your skin, always best to just document it, so that if we have that hearing to continue, you can bring that in front of me, but don't respond to it. I know it's a hard thing to ask, but nonetheless, I try to make these fair for all the parties. And
that's fair. I will say I definitely have blind spots throughout my life. I have missed many times, and I do really respect. So like, I'll know somebody, like my sisters will step in and be like, nope, that one's full of shit. And I didn't think so. They're like, nope, I'm a woman. That one's lying. Yesenia will do it sometimes. Yeah, a lot of people that are closer, like, I just admit I miss it, but they're always right. They are always right. Women read women much better.
That's my goal here, and simply, keep everyone safe is a important second goal. So that's what we're trying to do. I appreciate both of you showing up and speaking very clearly on your own behalf and bringing in evidence today. That was very helpful. So thank you very much. Both of you have a safe weekend, and like I say, it will remain in place till September, upon which it'll expire unless Ms. Gonzalez submits ahead of time for an extension.
All right. Thank you, Your Honor.
Thank you all.
There you have it. Fun happy hour. I think I need, in fairness to the Latinas, we all love the Latinas. Everybody loves Latinas. I've just heard, or so I've read, that they can, they can get a little jacked up sometimes. That's not been my experience. There's a good example. Like, just so you know, like in my personal life, because you already know, like Yesenia is really even keeled. But she works with me, and there are some restraints on her. But I mean, yeah, I've spent a long time with her, and she is very calm and collected. But I also send her checks, so I probably don't get the the usual stuff that, say, somebody in another position would get. Yes, she puts up with me. I'm nice to her too. No, I mean, in fairness to Latinas, I say that they're dangerous. I mean, all women are dangerous. That they're a little more extreme at the edges, not much. Like, if things are going well, they can go really well. If things are going poorly, they can go really poorly. If you average it out, it's really the same as everyone else. It's just a little more jacked up on the margins. So I've heard. But what would I know? I'm just a simple country attorney trying to bang out a living in the Midwest. Thanks for coming out. I appreciate it. Behave yourselves. I'm not bailing you out.